Yeah, I'll tell you. Yeah. That's the thing. So your document, just because I've read this, they're all in chronological order, which is A102. So we're going to to the judgment and give that over to you. So it's just easier for referencing. I'm going to give it to the judge. Yeah, I'll give that to the judge. Is it upstairs?
Is counsel ready?
Yes.
Yes.
I'm just going to try and found them.
All rise, please. Your Honour, today we have a hearing in the case of CFI 004 of 2017, the estate of Christos Papadopoulos and Standard Chartered Bank. The claimant is represented by Bushra Ahmed, Lease Counsel from KBH, and the defendant represented by Baker & McKenzie, Lead Counsel, Fahaz Khan.
Yes, Mr. Khan.
Your Honour, 15 of the court, I appear on behalf of the defendant bank making the application before your Honour today. My learned friend Mr. Ahmed and Mr. Dylan Malone appear on behalf of the claimant respondent. My Lord, may I check, first of all, to see that you have all the relevant documentation that's been sent through? I apologise, it may have been in drips and drabs. First of all, an agreed hearing bundle.
Yeah.
Secondly, defendant's bundle of authorities.
Yes.
Thirdly, the claimant's bundle of authorities.
No.
No. Sorry, was that no?
Well, we better see this. It must be. Could you go and check that it's.
With the claimant's skeleton argument as well, please. Thank you.
Yeah.
My Lord, then we have what we refer to the defendant's additional documents. You may not have had a hard copy, but it's been, I believe, filed with the court and sent to the other side.
Frankly, I don't know what you're talking about, but I certainly haven't got it.
Well, if I may, hand up a file when your clerk's back.
Yeah.
There may be an issue with some of those documents.
Okay.
My Lord, just to take this time whilst your clerk's away, sorry to interrupt. Initially, the defendants wanted to put in extra documents in this hearing, and we had objected because the documents in themselves we said were not relevant to the application, and some of them were redacted, and also they were out of context. However, this morning I've spoken to my learned friend and advised him that that objection is not sustained on the basis that the claimant would also like to put further documents in. And so there is now no issue. What we have taken the liberty to do is produce the documents that the defendants wanted in chronological order, and we've also paginated them A1, A2 and so forth for the court's assistance. We've done the same exercise with the defendant, the respondent's documents rather.
Are they all in one bundle or two separate bundles?
They are in two separate bundles, just so that you know. So A1 and so forth is the applicant's documents,
right.
R1 so forth are the respondent's documents. What we can do is put them in one bundle for you and paginate them if that makes it easier whilst your clerk's outside looking for the claimant's
Yeah, that
authority.
would be sensible.
Yes, well I think we've already done that, but I've already done that exercise. Do you want to?
Your Honour, I haven't seen, I've been handed this morning, but I haven't looked at, had a chance to look at the documents that the claimant now seems to rely upon. I'm not suggesting we necessarily take an issue with them, but I just haven't had an opportunity to look at them. So I will, if I may, leave it until my learned friend makes a submission and reply to see what the import of those documents is, if any, and deal with any objection, if any, in my reply, if I may.
Okay.
Grateful.
Thank you very much. Sorry, just hang on there. Is this a new skeleton?
Judge, that was the skeleton that was filed, and I don't think that's in your papers because it was filed together with the authorities.
But I mean, I have a skeleton.
Oh, very good.
But it's
the same
it
one.
has a different heading on it.
That might just be because of the estate.
But if it's the same, then
It should be substantively the same. I wasn't aware of the...
Yeah. Right, these are the additional documents for both sides.
No, we're just marking up. We're putting them together in chronological order and page numbering them for your reference.
Aside from that.
Just in relation to the claimant's legal authorities bundle, a lot of the authorities we rely on are contained in the defendant's application authorities bundle, but I'm suggesting if there is anything other, then it may be that we can hand up clean
That makes
copies.
more sense than having two bundles containing the same.
Yes, there will be references made to the contract law and, for instance, the implied terms and unfair contracts term, but I'm assuming you have your copies of the laws there and then you can.
Don't assume that.
Well, I can hand up clean copies of those.
Yeah, well, you'll need to produce them. I mean, I'm sure I can get them, of course, but I don't have them immediately at hand.
Well, let's see how we get on. If there are any authorities that you need for the claimant, then we can hand those up and get those for
Right,
you.
okay.
Do you want that extra? So, my lord, just as an extra housekeeping matter, we do have a Court of Appeal authority that we are relying on. The other side do have a copy. If I may just hand a copy of it. This is not in the defendant's bundle. Thank you. What's on 40, 41?
Okay. Well, you can hand it up as long as you've got a hole in it. Look, so. Have you got a...
I don't.
Because I'm going to put it inside the authorities bundle, otherwise we're just going to go down. Unhappy mess.
So if that's going, is that going at the end of the defendant's
I'm going to put it
authorities
at the end of
bundle?
the defendant's
Yes.
legal authorities bundle.
So that numbering.
From page 299 onwards, okay? But, I went past it.
The last page of my defendant's authorities bundle is 318.
That's right, you're quite right. I failed to turn.
So that would be 319.
Thank you very much. Okay. Right, is that?
And we're just finishing paginating the chronological extra documents.
Okay. Thank you. Right.
My lord, before we do start, I'm just curious because you mentioned when my learned friend was on his feet that the title of the skeleton argument was different to the one that had been just handed to you. I just want to check that you've got the correct skeleton argument.
Okay. Have a look at mine. As you can see, the heading is slightly different. That's the only thing that caught my eye.
Oh, yes. Strike out and to be kicked up. I think yours is the correct one. Yes.
Well, I printed it off the
Yes.
set in London. Thank you. Thank you very much.
Right, Mr. Chairman. My Lord, I'm grateful. This is an application to dispose of the whole of the claim. Alternatively, the whole of the the claimant's defence to the counterclaim. We say by one of two routes. It may assist Your Honour to go to the main bundle to look very briefly at the application notice.
All right.
Your Honour, if I can ask you to turn to page 125.
Yeah.
You'll see there, under Part A, we set out the bases for the application. It's either immediate judgment under Part 24 or strike out under Part 4.16 in each case. Cost of the proceedings of 3, And then at 4 you'll see, in the alternative to the summary judgment application, there's an application for a conditional order that a payment be made into court.
Yeah.
Now that's on the basis that if the application fails but only just, Your Honour feels that the payment should nevertheless be paid because of the improbability of the success of the claim at trial. The evidence in support of the application is contained in 2 witness statements. The first witness statement of Miss Bijlani, for your note, that's at page 127 onwards.
Yeah.
I may take you to that in due course. And then the second witness statement of Ms. Bijlani at 239. That's a far shorter statement, and in essence it responds to 1 or 2 points raised in the witness statement of Mr. Papadopoulos, made in response to the application. And that's at page 163. I should note, Your Honour, that Miss Bijlani is not here today in court, and the reason for that is that she's had an illness in the family and has been unable to attend. But I hope that's not going to prove a problem. Of course, Your Honour would have been aware that Mr. Papadopoulos sadly passed away earlier last year, and so he's not here either. I've handed up a defendant's bundle of documents, but that's now been consolidated with the documents referred to by Ms. Ahmed in her housekeeping submissions to you. That should be all of the documentation that you have. Now, my Lord, in relation to immediate judgment and strikeout, both skeletons set out in some detail the law that applies. In our skeleton, it's at paragraph 20 to 23, and I don't intend to take you through that now. It seems to me it's largely uncontroversial.
Well, there's quite a good summary in the judgment of Justice Robert Giles. I can't remember what it's called now. Quite recent, of this court.
Yes.
On the topic.
I'm grateful, Your Honour. And it's really a question
So
of...
I wasn't going to look anywhere else, I have to.
Your Honour, I'm content with that. As we say, it's a question of emphasis and application to the plea claim and the defence to the counterclaim, which no doubt you'll hear submissions on. In that context, the only other authorities that it's worth noting at this stage are the English bankers' bonus cases where there's been a summary judgment, which is the corresponding provisions to the immediate judgment jurisdiction in this court. And there are 2 cases. One is Keene Commerce Bank.
Yeah.
I'll take you to that in due course. But that's in the defendant's authorities bundle at page 78 onwards.
Yeah.
And secondly is Pastoral and Deutsche Bank,
Yeah.
a judgment of Mr. Justice Singh in the Queen's Bench Division, the English High Court. Again, another summary judgment on a banker's bonus claim. That would, in our submission, assist you, not as much as Keene, but it's of assistance, and there's additional supper reason to our claim. And that's found at page 232 of our authorities bundle. They're referred to in our skeleton, and I will take you to Keene in due course. The application. Your Honour, you'll be familiar with the essential facts of the underlying claim. It's one for a bonus arising out of a settlement agreement. And in essence, the claim is that the bank, in breach of the express term of that settlement agreement, alternatively, in breach of an implied term of good faith, in essence, it said the bank decided not to award the claimant a bonus, and it said that decision was irrational and perverse, according to the case law on good faith that Your Honour will be very familiar with. The defence is, firstly, that the claim has been settled by the settlement agreement. There's a general release clause in clause 14, and we rely upon that primarily as our basis for strikeout of immediate judgment. We also say that if we're wrong about that, then the exercise of discretion is one that the bank had an absolute right to engage. There's no obligation or implied contractual limitation to that exercise of discretion. We're wrong about that. We say the exercise of discretion was in any event rational, and the pleaded claim in relation to perversity and rationality is, given the very high bar set for such claims, is hopeless. And finally, a fourth basis for the application is we say that the settlement agreement contains provisions which give rise to the counterclaim. If a claim such as this was brought, then the settlement agreement provides that we're effectively indemnified by the claimant, and that's clause 17 and 18 of the settlement agreement. Now, if one groups those together, really there are two ways in which the application can be looked at. One is pure construction points, and the second is the bonus discretion exercise point, and that's the way I'm going to take it, Your Honour. I will take you to Ms. Bijlani's first witness statement, just to show you how the application is put there. That starts at page 127 of the agreed bundle. If I may take you to paragraph 22, which is on page 132. That's the first.
This is pure argument, isn't it? This section of the statement.
Well, Your Honour, I have to concede that maybe parts of it fall into that category, but the essential purpose of the statement was to present the documentation and identify the relevant provisions.
But I mean, this is pure argument. I'm not saying there's anything wrong with it. I'm just saying it's a slightly surprising content of a witness statement of fact. There it is.
Yes, Your Honour.
These are points that you're going to make. I don't think you really need Ms. Bijlani's support.
Well, Your Honour, what I'll do, if I may, then, is just give you the reference, the part of the statement which identifies the basis for the application.
Well, I've read it.
I've read it. Your Honour, I'm grateful.
But I mean, I'm increasingly disturbed that it really isn't really a witness statement, but there it is. It's a piece of
Your Honour,
pretty prolonged argument.
Your Honour, the point's taken.
Not quite as long as the reply, which exhausted me, I have to say. Must have been the most prolix reply in the history of pleading, actually. There it is. Yes.
Your Honour, the first ground is that clause 14 had the effect of settling.
Yes. Shall we have a look at
any
it?
agreement? Yes. What I propose to do, Your Honour, is to take you through first the employment contract, because we say that's relevant documentary contract, and then take you to the settlement agreement itself. So, just to summarise, it's clause 14 that we're concerned with. That's a release. Clause 17 and 18 relate to the basis for the counterclaim, and then clause 13 is the right to be considered for a bonus.
Yes.
Those are relevant provisions. As I say, we'll look at the employment contract and the settlement agreement. Now, the employment contract starts at page 17 of the agreed bundle.
Yeah.
See there, it's document dated 17th of December 2014. The first line notes that, Dear Christos, further to recent discussion, I'm writing to confirm details of your transition to local terms in Dubai, effective from the 1st of January 2015. Now, the claimant had been employed since 2006. It was transitioned from, I believe, a Singaporean contract to a contract based out of the DIFC.
Thank you.
Now the first clause we rely upon is clause 2, that's at page 22. First is the contractual terms. And you'll see there that while reference is made to bank policies and procedures, these are not contractual in effect unless otherwise expressly stated. The reason that's important, we say, is because a significant amount of emphasis is placed by the claimant upon the grievance policy and failure to follow certain provisions, allegedly, of that policy. And given this is a breach of contract claim, we say that's an important provision to explain the relevance of the grievance policy. The next clause is clause 6, compensation. That's on the next page. It starts with the base salary, and then at 6.1, then goes on at 6.4, etc., to deal with various other sundries. So there's pension payments, allowances, etc. This is what we would refer to as normal payments. Over the page, at page 24, we have the discretionary variable compensation heading, and that essentially provides that clause 6.8 onwards for the bonus. We rely in particular on 6.8 and 6.9. 6.8 says you're eligible to participate in the plan. We say that's important for reasons I'll come on to. Then sets out a number of factors that's taken into account. One of those is that's the claimant's adherence to the bank's stated values. Then rely upon 6.9, the second sentence. So the bank retains absolute discretion as to the size of the award to be made under the plan. Also ask your Honour to note 6.10, which said ordinarily bonus awards are only applicable whilst in employment. The other provision which we say is of relevant background to the construction of the settlement agreement is at page 29. Clause 11 deals with termination. .1 says the bank is entitled to terminate your employment with immediate effect and without notice or compensation. And then over the page at 11.4, provision provides that as long as it acts lawfully, the bank shall be entitled in its absolute discretion to terminate employment. Corresponding language to 6.9, which relates to the absolute discretion to award a bonus. My Lord, the final provision I'd ask you to note is at 11.7, which is on page 31. And at the very bottom there, it deals with garden leave. And what's interesting at the end of that provision at the bottom of the page is that there's an express reference to express and imply duties of fidelity and good faith. I'd ask you to note that, Your Honour. I'll come back to that if I may. Finally, paragraph 21, page 36. Specifically refers to the grievance policy as being non-contractual. Your Honour, if I may then take you to the settlement agreement, starts at page 45. Now, it's uncontroversial between the parties that this was negotiated over several weeks. That's language taken from Mr. Papadopoulos' witness statement. And there was, to put it colloquially, lots of toing and froing over the terms. And there are inevitably lawyers on both sides. For the part of Mr. Papadopoulos, there was a contribution made by the bank to the cost of his legal advice. On the front page, there's what is in effect a recital on the termination of your employment and settlement terms. And again, a reference to, we say, the negotiation, where it says, I refer to our discussion with Bill, Neil and myself, and like to confirm the terms which have been agreed with you in respect to the termination of your employment with Standard Chartered. The reason that's important, we say, is these aren't standard terms. It was negotiated. In that respect, we'll rely upon the fact that it's a commercially arm's length negotiated agreement, rather than, for example, like an employment contract, which is a standard contract, which is going to be subject to certain implied terms. It then said in the next paragraph what the purpose of the settlement agreement is. The purpose of this letter is to reflect the party's intention to settle any claims you may have against the bank, in accordance with GIFC employment law as amended, annual contract of employment, dated 17th of December. And it sets out the terms below. Now, the essential bargain reflected in the settlement agreement is as follows. In clause 1, the bank terminated Mr. Papadopoulos' employment, and the termination date was the 31st of December 2015. He then went on gardening leave with effect from the 2nd of October until the end of his employment in December. And over the page at page 46, one has a section entitled Payments, Benefits and Deductions. Now, in clause 3, Your Honour, there's a reference to normal remuneration and benefits until the termination date. Then said, thereafter you shall have no entitlement to any remuneration or benefits whatsoever. We then have clause 4 and 5, which effectively provide for what's referred to as the compensation payment. I'll still honour to read that, if I may. And clause 6 makes plain that 4 and 5 refer to the compensation payment. So we have, In Clause 3, what we refer to as normal remuneration or normal payments, and Clause 4 to 6 provide for the compensation payments. That's effectively the bargain. The bank can terminate the employment and procure the agreement to this settlement agreement, including all the relevant clauses, which I'm going to take you to, and in consideration for a payment of some $1.5 million, I believe. We then come to Clause 13, on page 41. And this is the bonus provision. It says you will remain eligible for consideration to a discretionary variable compensation award for the performance year 2015. Then sets out a number of factors, including the bank stated values that will be taken into consideration. There is no entitlement to or guarantee of an award, and then the award will be subject to the group's clawback policy, etc. And the settlement agreement in the last sentence anticipates the decision will be made in March 2016. That's after the termination date, which was December 2015. Your Honour, it's important we say that, as the contract makes clear, bonus payments, if any, or the exercise of a discretion whether or not to award a bonus, is potentially gives rise to a future payment. And that's something that, again, I think the parties are ad idem on. It's referred to in the claimant's skeleton argument, that it's a future payment that's referred to. And that's important, we say, when one comes to the settlement of claims provision of Clause 14 and onwards. Your Honour, I'd ask you to read that to yourself, if I may.
Yeah, I read it.
Thank you.
Several times, but skeletons several times.
Yes, Your Honour. Over the page, we also rely on Clause 15, which we say is relevant documentary context to construe Clause 14. You further agree and acknowledge that the salary and benefit under paragraph 3, plus the compensation payment, pausing there, Your Honour, that's the provisions I just showed you, Clause 3 to 6, constituting the normal payments and the compensation payment, are full and final amount which may be due to you from the bank or any associated company in connection with and or arising out of your employment by the bank and or its termination up to and including the termination date. And so on and so forth. And then Clause 16, for good measure, the claimant waives any claim he may have. So Clause 14, read with Clause 3, 15, and 16, provide for the scope of the general release contained in Clause 14. I'll make my brief submission when I get there, Your Honour. Just while we're in the settlement agreement, we then go on to Clause 17 and 18 to look at clauses which provide the basis for the counterclaim. There's one distinction between these two provisions. Firstly, Clause 17 makes clear that if the claimant institutes or continues any proceedings against the bank of the kind set out in paragraph 14, so that's the general release, then that has certain consequences, which would effectively negate the financial consequences of a successful claim by Mr. Papadopoulos. Clause 18 doesn't cross-refer back to Clause 14. It just says if you present or bring any complaint or proceedings, action or claim before the DIFC or anywhere else, then that also has, we say, the same financial consequences. That's the basis of the fourth part of the application, which relates to the counterclaim. On the next page, two more provisions. Your Honour, I'm grateful for your patience, so I hope this will actually be submissions are. Clause 20 on the next page. Stating the obvious, by reference to clause 17 and 18, that if you bring any claims, then we will bring a counterclaim, which is what's happened here. And then over the page, page 50, clause 28 is in the nature of an entire agreement clause. So it's the entire agreement subject to savings. The first saving is except as expressly provided in this agreement. And then there's a non-exhaustive reference to certain provisions relating essentially to post-employment restrictive covenants. Again, in the ordinary way, those are accepted from the entire agreement clause. And then finally, my Lord, it's been signed by both sides. This copy's unsigned by Mr. Papadopoulos, but I understand it's uncontroversial that it was signed by both parties. So if you are in agreement with the aforesaid terms, etc., please sign and return. And then again, by signing this agreement, I acknowledge, that's the claimant, that I understand the terms set out above in the bank's letter to me. Now, briefly, that's relevant, we say. Given this was negotiated, given it was arm's length, given there were lawyers on both sides, and given this acknowledgement, much of what's said in Mr. Papadopoulos' witness statement about his understanding of the agreement and why, as far as he's concerned, it doesn't mean the things which we say in the defence it means, is not really of assistance to Your Honour. It's subjective evidence, and in any event, the agreement speaks for itself, and it's been acknowledged and negotiated at arm's length with this result. That's a much better, and we say, admissible clue to what the contract means, rather than the various matters set out in Mr. Papadopoulos' statement, even if that's taken at its height as it must do on this application. I'm grateful for your patience, Your Honour. I'll now take you through my submissions on, firstly, clause 14 and clause 16, then clause 17 and clause 18, and then clause 13. It may assist your Lordship to have clause 14 in front of you. First of all, it's plain the language is extremely broad. And if one took the natural meaning of the words, then we say it's unarguable that it includes a claim for breach of clause 13. That's prior to getting to any documentary interpretation or any implication of terms. Just looking at the words, it includes the potential future payment of a bonus under clause 13, which we say is this claim. As BCCI...
Just to make sure I understand where you are on this. As I understand, it's your case that clause 14 encompasses any compensation under the bonus scheme.
Yes, Your Honour.
Yes. You have to say that because you rely upon clause 17 to say that if you pursue proceedings in relation to a right under paragraph 14, then you lose your entire compensation. And you're saying that the effect of seeing through the bonus has that impact. Therefore, clause 14 encompasses the bonus, correct?
Yes.
Yeah. And it follows, I think, as Ms. Ahmed would put it, if you could strike out clause 13 completely, without having any impact on this agreement at all.
We say no, Your Honour.
But why do you say no? That's the difficulty I'm having. You say that although it's said in terms that the former employee remains eligible for the least consideration for the discretionary compensation award, the next clause actually abandons that claim, so that we could strike out clause 13 completely. Now, what have I got wrong?
Your Honour, we say that there is a right to be considered for a bonus. That's distinct from a right to sue upon a breach of that provision. So what the parties agree...
Well, okay, you say that paragraph 16 irrevocably waives any rights in relation to paragraph 14. Paragraph 14 includes the bonus, so he's waiving any right, eligibility, discretionary or otherwise, in relation to the bonus. That's the difficulty I'm having with this point.
Well, Your Honour, I see that. I'm grateful if you ventilated.
Well, I think that's what Ms. Ahmed is saying in her skeleton.
Yes.
That clause 13, it would be a surprising conclusion that the parties took the pains to retain the eligibility for the discretionary bonus if in the same breath, or at least the next breath, they're abandoning it.
Yes.
Well, I need some help on that.
Well, we say that there is a distinction. Clause 13 contains two potential rights before one gets to clause 14. One is the right, and this is the express right, to be eligible for consideration for a discretionary variable compensation award, firstly. Secondly, there's a right to sue upon a breach of that right. And what clause 14 does, it doesn't interfere with Mr. Papadopoulos' right to be considered for a bonus. That's what the parties agreed. The bank said, we'll consider you for a bonus come March. But the parties also agreed that effectively Mr. Papadopoulos could not sue upon that. And we say it's an important distinction. If one comes to clause 15, it's quite clear that what can be sued upon is a failure to make the payments under paragraph 3 and the compensation payments. And that's at clause 4 and 5.
Yes, actually.
And it's important, the distinction is those are all paid 10 days after the settlement agreement ended into, so sometime in August or September, before termination. But then what the bank says by clause 13 is, we'll consider you for a bonus. And then clause 14 it says, as a future payment. But clause 14 says all future payments anticipated by the parties cannot be sued upon.
Suppose the bank considered the discretionary bonus and decided to award him one that refused to pay it. Could he sue on that? On the face of it, not.
Well, I think that would depend on any necessary implications into clause 13.
Well, no, you need something to deal with 14, 15 and 16, don't you? Well,
one could do it both ways, but in substance what would need to be done is to imply a term that if a bona fide decision is made to make an award, then that will be paid.
Well, they make an award in March 2016. This contract is dated sometime 2015, I can't remember when.
August.
Yeah, okay.
Probably, yeah.
And they make an award in March 2016, and your client sits there waiting for it. And the bank then say, well, I'm very sorry, you've accepted the terms of this agreement for the final settlement of all claims, costs, expenses, rights of action, with any kind, contractual, statutory, otherwise. So I'm very sorry you can't sue on this. And if you do sue on it, we'll rely on Clause 17.
Well, Your Honour, where I think you're going with this is to say that this is a surprising result and possibly unfair.
Sorry, say that again?
It's a surprising result as a matter of construction and possibly unfair. That, as I understand it, is
No, I'm just trying to see what it means, that's all.
Well, looking at Clause 14...
You can always enter into an unfair agreement. That doesn't worry me at all. I'm just trying to feel my way to the proposition that you advanced, that, and I think I understand it. You say that the clause, the effect of Clause 13 is simply to allow the prospect that the bank might award a compensation under the plan, which is, of course, the plan in the contract. But that's entirely discretionary, and even considered, as I see it, discretionary, even if they decide that he's entitled to a payment. Surprising arrangement. Anyway, there we are. That's one problem I'm having.
Well, I'll try and assist you.
Yes, thank you.
I see that this part of the submission may not immediately be in favour. Clause 14, of course, does not exclude any, on its face doesn't, there's no saving provision in terms of any type of claim.
Right.
It says any claim. But Clause 15, we say, is important because it identifies what's contemplated by the parties as to payments that will be made and are enforceable, we say.
Yeah.
And that is the normal payments and compensation payments provided for under Clause 3
Yeah,
to
the
5.
last sentence again repeats you're not entitled to anything else,
Yes.
including presumably a bonus that's actually been awarded to him.
Well, on its face, yes. The only
That's the
caveat.
point I'm making.
Well, the only caveat to that is that one can. That's a difficulty for me, Your Honour. I see that, but that can be dealt with by way of necessary implied term.
What's your implied term?
The implied term will be that if, that the discretion has to be exercised in good faith, and that will
That's a
encompass
different
making
point,
the
let me
payment.
say so. I'm not talking about the exercise of discretion to award a bonus. You're now talking about an implied term which apparently overrides Clause 14 in circumstances where a bonus is in fact awarded. That's a completely different point.
My
My band is around implied terms. I'd rather like to write down what the implied term is before I consider whether it's a legitimate, necessary inclusion in the contract.
I think it's fair to say that the express terms of this contract don't anticipate the if I may say so, unusual circumstances that you've posited that may take place. So an award's
I'm
made,
trying to
but
pursue
no
this
payment.
contract to make sure that it works properly, that's all. And of course it may not work, and that's life sometimes. On the whole, one tries to construe a contract so that it actually works.
Yes, we say it does work if one separates out the entitlement.
Well, the way you make it work is to say the answer to my question is that you've got to imply a term, whatever that implication is, I'm not quite sure, but there it is.
Well, if an award's made, it has to be paid.
Yes. Which is absolutely, completely counter to the express terms of the agreement. That's rather the problem with it. Anyway, there we are.
Yes.
I'm just trying to raise the points that strike me.
Yes.
I mean,
I'm
remember that
grateful.
this is an application for, in effect, a strikeout. You may be right. And I'm not anxious to embark upon a definitive decision unless I have to. But on this first element of your case, I have a bit of a problem, that's all. It may be in due course you'll be proved to be completely right, that all that this contract leaves is a hope of a bonus, an eligibility for consideration without any promise to pay it. That may be right. But I don't, as a matter of construction, one might well come to the conclusion that's exactly what a contract means, or on the other hand you might think, well, the point is arguable. I don't know.
Well, I will, if I may, want to make one final point on this, which is, if one turns it around and clause 13 is effectively accepted from clause 14, so it's not settled.
Right.
The problem is, if one looks at not just the terms of clause 14 itself, which refers to future claims, so a claim for a bonus award in March 2016, which is after the termination date. Also, one looks at clause 15, it's difficult to see how that would work, because it makes it clear that there are certain provisions which will be paid in full and final amount, and those are in paragraph 3 and the compensation payment.
Correct. Then there's the second sentence.
Yes. So if I'm wrong, Your Honour, and dealing with sort of your discomfort with my reading of clause 14 and 13 together, clause 15 is, we say, so far as there's any ambiguity, clause 15 makes it absolutely plain that at that the 31st of December 2015 termination date, all the payments up to that date, the normal payments and the compensation payment, is all that can be sued upon. And any payments or any claim thereafter that may be the subject of proceeding have been settled by clause 14.
Yeah.
The draftsman's gone to some trouble to make it clear that following the termination date, nothing else will be owed by the bank, in fact, and nothing will be paid.
Correct.
Subject to the right to be considered for a bonus, which is not a right to a payment, it's just a right to be
That's not a very
considered.
valuable right, is it?
Well, if it's subject to an implied term of good faith, my primary submission is it's not.
All right, assume,
But if it is-
yeah, all right, assuming that's a different point. Assume that a bonus is due either because they think it's due, or they reasonably think it's due, or they rationally think it's due. You're saying you're not entitled to it. I think that has to be your argument.
Yes, it is.
Yeah.
You're right. But just focusing on what that valuable right is in clause 13, you may not sue upon it, you may not sue upon a failure to award a bonus, but you have a valuable right because it may be, this is my fallback position, but it may be that it's subject to an implied term of good faith. The bank has to exercise it rationally. What the bank can't do is say, well, now he's signed a settlement agreement, let's turn our mind away from awarding him a bonus. Or let's not award it to him because we have some ulterior motive.
Oh, that's a completely different point. I was contemplating they exercised a rational decision in determining that the claimant is eligible for a bonus, but then decide not to pay it. That's the point I'm making.
Yes. So, sorry, Your Honour, I was dealing with whether or not there's any valuable
And as soon
right
as
in
the
13.
claimant sues on it, he loses everything. I understand your case. Anyway, there it is. I'll feel around for a bit, but I'm having a problem with it.
I won't press you upon it.
Okay.
Certainly we say that even if it's barely arguable, we say that given what's set out in clause 15, and given the overall construction of this agreement, the draftsman intended to exclude any claims other than those contained in 3 to...
But it is an extraordinary agreement to reach, isn't it? That's what, as a matter of commercial sense. I'll accept a very large sum of money in compensation, and I'm not entitled to anything else. You say I'm eligible for a bonus, and you'll think about it, but you may award me one, but you're under no obligation to pay it, and if you fail to pay it, and I see what it is, I lose everything. That seems to be your construction of this contract, and I think it's possible, but it's commercially surprising.
Your Honour, on this part of my submission, I'll take you to one case and
Thank you.
one section. You'll be well familiar with it. It's BCCI and Ali in the House of Lords. It was the first of several BCCI cases. It's in the defendant's authorities bundle, page 34 onwards.
Yes, thank you.
You'll recall it's a case about stigma damages. BCCI was run in a dishonest way. Mr. Ali was employed by BCCI at the relevant time. He then came to seek...
frankly, I don't know the case here, but there it is. To the extent I know the facts, know that. Let me just quickly read the headline. Entertainingly, Lord Hoffman dissented, particularly as it's entirely based upon his own analysis of the proper construction of the contract. Anyway, yes, now what's the point? What's the proposition that you're advancing?
The proposition is really what's contained in the speech of Lord Nichols at paragraph 27 to 29.
Thank you. Let me just read that, shall I?
Yes, I'd be grateful, Your Honour.
Yeah, well, I've read that.
Yeah. So the ballpoint from that, Your Honour, if I may say so, is that when construing a general release clause, one has to look at what was in the contemplation of the parties. So there is as a matter of construction.
Well, the one thing that was contemplated was a bonus.
Well, looking at clause 14, what it says is that what's contemplated by the general release is claims arising from or in connection with employment or the termination of the employment.
Correct.
So we say the settlement that any future bonus payment is in connection with or arises out of employment.
Well,
or termination thereof.
I take that point, that if one just confines one gaze to clause 14, it would potentially encompass a bonus payment. If clause 13 wasn't there, then I can see your point. The question is, how do you construe 13 and 14 together? Anyway, okay, thank you very much for that. Sorry, let me just make a note. Thank you.
Your Honour, as well, just for your reference, in terms of principles of construction, relatively recent case of Arnold in Britain.
But don't worry.
You'll be familiar with that. It's at page 189.
Yes, well, thank you for that. I mean, I'm very familiar with it.
Well, we rely in particular on paragraph 20. If I ask you
Let me make sure I grasp the point of that. 189.
Page 115.
Thank you. Yes, well, I mean, the reality is, the whole purpose of this analysis is that you must look at all 7 factors
Yes.
together. Yeah, okay, thank you. That's very helpful.
Your Honour, those are my submissions on clause
Thank you.
14, the general release. Moving on briefly to clause 17 and 18. Clause 17 effectively piggybacks on the construction of claims that are caught by clause 14.
Right.
So if you're against us on clause 14, the settlement and the bonus payment falls out with that general release, then clause 17 doesn't help us.
Correct.
Clause 18 is wider than that. It doesn't cross-refer back, as I see, to clause 14. And 18A.
But are you claiming damages for breach of clause 18?
Yes.
Oh, I see. And what's your loss?
We say our loss is, if we're wrong on the claim,
Right.
any payment we make plus our costs. Our primary case effectively mirrors what's set out in 17
Yeah.
A and
I
B.
understand. But you're saying, assuming that 17 doesn't afford a bar to a claim, or more importantly, a right to recover all the compensation, you now rely on clause 18A to say that a breach of that provision entitles you to recover all the compensation. Is that the point you're making?
Yes, so any damages awarded, so it refers to the bringing of any complaint, proceedings, action or claim. So the fruits of that, i.e. damages for breach of the bonus provision in clause 13, plus any associated costs, we say, is the measure of the award for breach of clause 18A.
So even if you sued on clause 3,
No, we say...
well, that's what I'm having difficulty with. That's another suit within the meaning of 18A. Did
Yes.
you say that doesn't give rise to a right to recover compensation?
No, because we say 18A has to be read with 15, which makes it plain that Mr. Papadopoulos had a right to...
Yeah. Well,
a
I
right
think this
to
is going
recover.
around to the same point, but necessarily, but then going wrong. Okay. Understood.
Now, the defence to this is obviously the construction point.
Yeah.
And secondly, it's said that it's an unfair term.
Yeah.
We say this agreement doesn't fall within the ambit of the relevant provisions. We deal with it essentially in paragraph 51 and 52 of our witness statement.
Paragraph what?
51 and 52 of our sentencing argument.
Thank you. Yes.
Now, briefly, Your Honour, it said against us that if these provisions have the effect of a matter of construction that we say it does, it can't be relied upon lawfully because of the unfair terms law.
Yeah.
It's a plea to defend. And we say the unfair terms law doesn't apply to the settlement agreement because first, it's not a standard document, it's been negotiated. And secondly, relying upon Keane, and I'll take you to Keane and this relevant passage when I get there, it only applies to contracts which are entered into by way of business.
The answer.
You have the point there. There's my submission on clause 17 and 18.
Yeah.
Clause 13 then, as I say, we put this in two ways. The first is we say that it's the bank has an absolute discretion under clause 13. Put another way, there's no implied term, whether of good faith or otherwise, that applies to the exercise of clause 13.
Can I just make sure I understand? You concede that if a claim for a bonus, if a bonus was considered during the course of his employment, there would be an implied term to act rationally.
Yes, arising from the duty of trust and confidence.
Right, okay. But you say that despite the fact that this is a retention of eligibility to recover a bonus under the plan, that very same plan, nonetheless there's no implied requirement for the bank to act in a rational or non-perverse manner. That's right.
Yes.
Yes. Okay.
Your Honour, we say that for the following reasons. Firstly, clause 13, in order to understand the mechanism for awarding a bonus and the consideration, one has to look back at the plan. And that's a part of the suite of documents that are taken into account for the purpose of the employment relationship. So you take the plan, how it works, and it's imported into the settlement agreement.
Yeah.
We say it's a separate agreement, and the right to be considered for a bonus is a modified right by reference to the employment contract. So there's an express right to be considered for a discretionary variable compensation award. Now the language of that is taken from the plan documentation. The reference in the next sentence to the plan. And in order, we say, for the duty of good faith, the duty to act rationally, to apply to clause 13, one has to necessarily imply a term. There's no other way, we say, of getting there.
I'm very sorry, you have lost me. I do apologise. As I understand you say, that clause 13 in retaining, and it is a retention, eligibility for consideration of a bonus, nonetheless has established some kind of modification of the plan to which is referred. Right?
Yes.
Well, I'm not understanding what is the modification?
Well, under the employment contract,
Yes.
there is implied by law a duty of trust and confidence.
Well, there's an obligation for any servant to
Under
act.
the IFC.
Yes.
Yeah. So there would be a duty to act rationally arising out of that implied term, you say.
Yeah.
But that's under an employment contract.
Right.
This is a commercially negotiated settlement agreement. So when one comes to the same process of implication,
Right.
there's no implication of law. And we say, following the ordinary principles of implication, there's no implied duty of good faith that fetters the exercise of this discretion.
So although there are expressed requirements for what should be taken into account, the bank need pay no attention to that at all.
There'll be a breach
The
of the
bank,
express
on the
term.
face of it, is obliged, for instance, to have regard to the claimant's overall contribution to the performance year. Assume he's been a great success and contributing substantially in a very relevant year. The bank can simply disregard that.
No, they can't, because it's we're talking about the express requirements, considerations. That would potentially be a breach of this contractual provision.
But as I was saying, they don't have to act rationally. They have to say, well, all right, he did quite well, but let's forget that.
Well, in order to get to the duty to act rationally, one has to imply a term into this agreement.
Well, I think you may be right about that.
Yes. So if
And you say that because there is no continuing employment, it follows there is no obligation of trust or confidence. Therefore, as I'm saying, it follows as night follows day, there is no implied term. And that'd be difficulty with that.
Well, we say that. We also say that if one looks at clause 28,
Yes.
it's an entire agreement clause.
I'm nearly done. Sorry. Yeah.
If you're that has the effect of ensuring there are no implied terms in this contract. So those are two bases we say, that there is no implied term to act rationally.
Thank you.
As to case law, I won't take you to it, Your Honour, but you'll be familiar with the case of Marks and Spencer, the recent case on implication of
Well, I'm pretty familiar with that.
terms.
Yes, yes.
And we rely upon,
I mean, that gets away from Lord Hopkins' decision that
Yes.
the implied terms are essentially a matter of construction. Yeah.
you have the point, it's
Yeah, thank
213 onwards and we
Yes,
rely upon
I'm grateful for that. Thank you.
14 to 31. That's out, but those are the three construction arguments.
Very helpful.
Your
Well,
Honour.
we're going to take a short break. If you don't mind.
Great.
Thank you very much.
All right.
No.
weirdest thing is I had an actual marked up copy. There we go. I had a marked up version.
Yeah, fine. Yeah. But that's fine.
I think it's going wrong.
I think it's fine.
I think it's
Fine.
So the British Russian judgment, the very
I think that's probably right. I have spoken the registry staff on the back of time. They've confirmed that there was
Yeah, I'm going to ask her to do
which is
That's fine. Yeah, I understand. But I think, do you want to go?
I think going forward, I think the position was taken. It's okay. Well, the applicant should be bringing copies of their things.
Yes.
They should be and that's, I think, that was probably the fallback. I think, by and large, they should have been talking, but we haven't done it with this back to the judge. So I think, it was absolutely the perfect storm. But if you've got other things, great, yeah, no problem. That's great. Thank you.
I need to take you through the settlement agreement again until the other paragraphs that he hasn't even referred to.
Just before you start, Derek, this is unbelievable. which this is all has been submitted online. The only difference is we have again put in the correct Court of Appeal judgment, which you said by the defendants. That's now the correct one. And in addition, that was handed up before, but it's now in the correct place, and it's just a long quotation of loads of these. And then the other thing is he mentioned himself, judgment to Justice Jones in NLG, the FTIC court, and that's just all that. Right, so you'll be first now. It wasn't unhappy about it. You know. Just to say, you know what to say about the wrong thing. Yeah. Because the correct Court of Appeal judgment is in there, and it's the Charles judgment.
Do you know what page it starts at?
It's going to be just exactly behind the index.
Yeah, got it. Thanks, Patrick.
council ready?
Yes. I'm going to get to you.
All rise.
Your Honour, vote for. Bonus, exercise of discretion under clause 13. I'll start, if I may, by taking you to the pleaded claim. Starts at page 2 of the bundle.
Yeah.
And the bonus is referred to under paragraph 17 of page 5. So under paragraph 13 of the settlement agreement, anyone eligible for consideration for a discretionary variable compensation award bonus. And there are some background facts relied upon. And then paragraph 27 onwards from page 7, one has a detailed section on the grievance process.
So which paragraph are you in now?
27.
27.
Yeah, so that's the grievance process.
Yeah.
Again, by way of background, but we'll see that it's relied upon as a particular irrationality. Then the grievance outcome, paragraph 35. And the grievance appeal, etc. And then one gets to the claim under the heading breach of express term of the settlement agreement at paragraph 42.
Do we have a list of what A, B, C, and D mean?
No.
No.
Yeah.
The rating.
So and then at 43 and 44,
Yeah.
relied upon as particulars of the breach of the express term.
Yeah.
And then at page 14 we have the separate heading, breach of the implied term of good faith, fair dealing and reasonableness. New paragraph 45. Now, the first point to make in terms of understanding the way the claim is put is there is no express term of good faith.
Yeah.
All that the express term requires is for the bank to consider making an award. And it says so in terms of paragraph 42. It then says that the claimant was perversely and irrationally assigned an unjustified value rating of D. The problem with this pleading is that there is no express term to act other than perversely or irrationally.
So the implied terms and allegations are A, the grievance process, which you say is ex post facto, so
Yes.
it's of no consequence, and the negotiation of the settlement agreement in bad faith, which is a completely different point.
Precisely.
The only allegations which could pertain to irrationality or perversity are those that seem to be applied to breach of some unidentified express term.
Well, yes, so far as 42 and 43 are concerned.
Yes, that's what I meant.
Yes. And it's not, I don't believe it's controversial. The bank did consider and make an award. So there can be, on the facts, on the agreed facts, there's no breach of the express term to consider making an award. So we say paragraph 42 and 43 just don't really apply so far as an express breach is alleged, which we understand to be the case here. The real claim is a breach of an implied term, starting at paragraph 45.
Yeah.
Now, assuming for the moment that you're against us on the construction of Clause 13, that there is an implied term, one then looks at what's pleaded, and it's, as you have rightly alighted upon, Your Honour, the grievance process, paragraph 45(1), and the negotiation of the settlement agreement, paragraph 45(2). And one's ex post facto, one's anterior to the decision.
Yeah.
Neither of them go to the decision itself.
Correct.
Now, if I may, at this stage, it may be helpful just to show you what the reasoning is for the exercise of discretion. Yeah. And that's to be found at page 153 of the bundle.
Yeah.
And it may assist, Your Honour, if you read that in full.
I will.
We rely upon the heading bonus and derating.
Yeah.
And Your Honour, that's supported, I won't take you to it, but for what it's worth, it's supported by the grievance outcome, which was after the event, but which reviewed the same material effectively by someone different to Mr. Winters, the decision maker. That's at R12 of the now additional bundle. R12 onwards.
Right, I'm not quite sure I'm following that. In the additional bundle,
Yes.
divider which?
Sorry, I believe it's in the clip handed up by my friend. I apologise.
Oh, I see, yes, it's got some.
Yes.
Yeah. Oh, gotcha.
Yeah, so strictly speaking, this is after the event.
Yeah.
And we say it's, the grievance process is irrelevant. But in any event, it just sets out the findings of the grievance decision maker by reference to what Mr. Winters had decided. Now,
Yeah. So now that R12 is a note of a telephone call dated the 11th of May 2016. The R13 is a letter to him from
right.
Miss Walkland. which I assume is the outcome of the previous proceeding.
Yes, that's the letter. I've got slightly different numbering, but that's the letter I referred to, 12th of May
Let me
2016.
just glance right through that.
Yes.
Yes, I've glanced through that. Thank you.
Yes, I'm grateful. The final document that's a clue to the decision made and is relevant is at page 156, I believe, of the bundle. It's going back to the main bundle. I apologise, Your Honour, for having to jump around.
That's right. Yes, I have that.
Yes, so this is an exhibit to Ms. Bijlani's first statement. It's effectively a document that summarises the comments made and the award rating for bonuses for years 2011 onwards, I believe.
Yeah.
But what I'm interested in is and what we rely upon is at page 156.
Yeah.
And you'll see there, if one turns it the other way around, as you have done, Your Honour, I see, the top entry relates to a decision made by Mr. Bill Winters, effectively a preliminary decision made at the half year.
Yeah. Yeah, I've got that.
Yes, and I rely upon this for two things. First of all, it said against us that Mr. Winters gave a B rating at the half-year point, so that makes a D rating at the end of the year irrational, or is a clue to the irrationality of that award. But two things. First of all, Mr. Winters, and this is uncontroversial, had been in post for 4 weeks, and so he'd simply adopted what the previous award had been, which was a B rating from the previous manager, Mr. Shankar.
Yeah.
Secondly, and perhaps more to the point, the reference to there being stylistic issues that have been a source of friction with London, Singapore-based seniors, we say is consistent with the D finding, D values rating given by Mr. Winters at the end of the year in relation to the decision in issue. While he'd only been in post 4 weeks, he'd already noted, and no doubt people told him, that there were stylistic concerns.
Yeah.
And that's the reason given for the decision. So it's by way of background, it supports the genuineness of the decision. Your Honour, we've set out in our skeleton argument paragraph 37 to 39. The approach to be taken, or has been taken by parity in the English courts on summary judgments in relation to bonus claims. I won't take you to the case of Keane, as I said I may do. I'll see what my learner friend has to say in response, to see whether there's really anything between us on this. But number of points we rely upon. Particularly the judgment of Lord Justice Mummery in Key as to the nature of the discretion, 38.1, the level of scrutiny at 50. And that refers to the case of Braganza. And also in Keene at 39 to 41, over the page.
Yeah.
And finally, paragraph 39, I set out from that case law what we deem to be the approach to be taken.
Yeah.
First, the claimant must be able to demonstrate some feature of the award or the circumstances in which it was made, which tend to show that it was irrational. And at that stage, the burden shifts to the bank to give reasons, cogent reasons for the bonus. And we say in this case the burden doesn't shift for the reasons I set out when taking you to the claim. And in any event, we say there are cogent reasons given by Mr. Winters, which are supported by surrounding documents. And given the exceptionally high burden, in fact the bank has a very wide contractual discretion, we say this pleaded case doesn't come up to scratch in terms of taking this case beyond a summary disposal. We rely particularly on the approach taken in Keene and the Deutsche Bank case, and I'd be grateful if Your Honour had time to read that, if judgment's reserved. But the relevant provisions are set out, relevant parts of the
So you invited me to read
Keene.
Keene.
I could take you to the relevant parts now, but it may not be a...
Well, you cited some, of course, in your skeleton.
Yes. Can I give you the relevant paragraphs?
Yes, that's a good idea.
Yes, maybe that's a good halfway house. So, paragraph 7 sets out the relevant provision in that case. Paragraph 12 sets out the relevant implied term. Paragraph 23 and to 26 set out the submissions made on behalf of Mr. Keene, the employee. 39 to 40 set out the approach to be taken by the court. 42 to 46 deal with the duty of trust and confidence. And at 58 to 58 to 61 is the decision of Lord Justice Mummery. At 59 he says Mr. Keene hadn't met the requirement for an overwhelming case. at a summary judgment stage.
Okay.
Let me take a moment, Your Honour.
Of course.
Your Honour, those are my submissions on the exercise of discretion. I've set out our position on the conditional order. I don't need to
I fully understand that.
unless I can assist you any further.
That's very helpful.
I'm grateful.
Yes, Ms. Allen.
I'm grateful, my Lord. Just dealing with the question before the court today, we say clearly in all the authorities there is some overlap between this test for a strikeout application and an application for immediate judgment. Clearly the strikeout application looks at pleadings, and I will take you to the pleadings, and the test for immediate judgment is that it will that there is no real prospect of succeeding on the claim, and for that, my Lord, I will take you through some of the evidence and the documents that have been put before the court on this application. My Lord, you made reference to His Honour Judge Giles's judgment in Hague and GFH, and clearly that sets out all the principles that the court must adopt in deciding whether or not to allow an application for strikeout and or immediate judgment. And it makes reference to the Easy Air case, which is in the defendant's bundle of documents. I don't know if you want me to take you to that just for your reference.
I don't know.
It's at page 97. That's just for
So
your
am I
reference.
looking at the wrong, which one was
Defendant's legal authority
I'm sorry.
bundle.
Yeah.
And just for your reference, my Lord, page 97 is the Easy Air case, which sets out the principles. If I can just take you to one more authority in the defendant's legal authorities bundle, it's the case of Pachuran, and that's at page 232.
Yes.
And not wanting to take too much time on this, if I could invite your Lordship to turn up paragraph. It's
So hang on, let me just. Why do I need easier?
Well, that sets out the authorities that Mr. Justice Giles referred to. Or
I see, yeah.
Yes, the principles.
Okay.
And Mr. Justice Giles referred to Easy Air in his judgment of
Now I want to go to Pachural.
Pachural, please.
Yes.
And this is a case where the claimant made a claim that the bonus wasn't as high as he thought it would be. Various principles are set out. But can I just invite you to turn up page 235, please? And again, the principles are set out at the end, sort of paragraph 17,
Yeah.
which you'll be very familiar with. But I just want to turn your attention to paragraph 18, halfway through, where reference is made to the case of Apogdido against Collins.
Yes.
And I don't think this authority is in any of the bundles, but it just talks about the burden of proof. The overall burden of proof rests on the applicant to establish that there are grounds to believe the respondent has no real prospect of success and there is no other reason for trial. The standard of proof required of the respondent is not high, it suffices merely so for us to rebut the applicant's statement of belief, and the facts must be presumed in the claimant's favour. And my Lord, I just draw your attention to that principle there. And therefore, my Lord, we say, having heard the applicant's submissions, that there is nowhere near, or rather the defendant, the bank, has nowhere near reached the very high threshold to establish that the claimant's claim is bound to fail. We say that that threshold is high and the applicant hasn't reached it at all. Just before I go and address my learned friend's arguments, I just want to make this final point, my lord, and that is this. You have a whole host of authorities before you, UK authorities, and we say that in the main, whilst they may be useful by way of interpreting the DIFC law, so as an aid to interpretation, the principles enshrined within those authorities are very different to the principles enshrined in the DIFC law. And just to make my point, if I can refer you to, for instance, the contract law, and you'll find that in the claimants authorities bundle, which you should have now, behind tab 1, and tab 1 is the contract law.
Yeah.
Part 5.
Yeah.
Article 49, Clause 49 of the contract law. Provides the court a useful checklist for, or rather to interpret and construe contracts. And we can see 49, intention of the parties. So whilst it may be useful to decipher and to read the UK authorities, we say that rather than the sort of what the reasonable man may have construed or how the reasonable man may have construed the contract, it's incumbent upon this court in the DIFC to look to the common intention of the parties and what the parties intended on how the contract should operate. Particularly if one looks at Article 51, relevant circumstances. In applying Articles 49 and 50, regard shall be had to all the circumstances, including the preliminary negotiations, practices which the parties have established, conduct of the parties, nature and purpose of the contract, and the meaning commonly given to terms of expressions and usages. And so, my lord, we say that this is a perfect answer for the court when looking at this contract to consider the intention of the parties in construing the contract before you. The second way in which we say that the DIFC law differs from the authorities that have been put before you is, again, staying with the contract law, and it's Article 57, and that refers to implied obligations. And, my lord, you have heard my learned friend talk about express terms of the settlement agreement and that there is no implied term in this contract of bad faith and so forth. We say that the DIFC law provides for that implied obligation applicable to all contracts in the DIFC, and therefore it doesn't need to, the court doesn't need to imply by looking at business efficacy, necessity, and so forth. All it needs to do is to look at Article 57 and apply those implied obligations to any contract in the DIFC. The third submission that was made by my learned friend, which I seek to debunk, is the implied term of trust and confidence. And my learned friend's submission was that there is that implied term to these agreements. We say no. In the case of Manor against Hertz, I think it was Mr. Justice Coleman back in maybe 2012, 2013, that stipulated that no such implied term of trust and confidence exists in the DIFC, and therefore, my lord, I would invite you to discard any submissions relating to that and look at this case through the prism of the DIFC law and not the UK authorities, although helpful that they are. Then turning to my learned friend.
But is that decision in your bundle?
No, it's not. I didn't realise my learned friend was going to make the submission to.
You could send me
Yes, it's Manor against Hertz, and it's Mr. Justice Coleman around 2012, 2013.
Perhaps you could send me a copy.
Yes.
Yeah.
Turning then to my learned friend's primary submission in his application, and that is inviting the court to construe Clause 14 in a manner that debars the claimant from claiming damages as a result. So, my lord, before I sort of get involved in my submissions, can I take you to the settlement agreement again? I know you've looked at this, but I'd like to take another look at it. there's a settlement agreement in the application bundle behind tab 3. Excuse me. My Lord, you were taken to various clauses in this, but can I invite you to turn to page 46, it's page 2 of the agreement, the settlement agreement,
Yeah.
and clause 3. Clause 3 sets out, clause 3, clause 4, clause 5 sets out the claimant's entitlements on termination. So we see that he's paid his normal remuneration and benefits until the termination date, which was the 31st of December. Then we see the end of service gratuity at paragraph 4, which is provided for by Article, I think, 62 of the Employment Law, DIFC. And clause 5 of the agreement provides for the notice and pension. And we see at paragraph 6 that all of those payments comprise the compensation payment in accordance with the DIFC employment law. Now this is important because clearly on termination an employee in the DIFC has various rights and entitlements afforded to it not only by contract, its employment agreement, but also by statute. Clause 10, this relates to the awarding of shares in the future. And we say this is an important clause as well because it relates to an act that the defendant, the bank, has to carry out according to clause 10 in the future. So it's something that's going to happen in the future. Then we see clause 13, and you've already looked at that, clause 14. Then if I can refer you to clause 24, this is a clause whereby the bank, in response to a written request, provides for a reference. The reason why I take you to this clause is, again, it provides for a future act, for the bank to undertake in the future. Then we see paragraph 27. My Lord, if any provision of this agreement is or becomes invalid, legal or enforceable in any respect of rental or the validity and legality or enforceability of the remaining provision shall not in any way be affected or impaired. Paragraph 28 you've seen. And paragraph 29, this is an agreement that is governed by DIFC laws, and therefore it's important to look at construction of this agreement through the eyes of the DIFC. The final page, my Lord, I just ask you to make a note. The penultimate paragraph, if you're in agreement with the aforesaid terms, please return both copies of this agreement to you signed by you for signing on behalf of the bank to PK Madappa. PK Madappa is the group head human resources. He is the person who signed the settlement agreement, and we say he was the person who was directly involved in negotiating this contract and negotiating the terms of this contract. You'll see that there is no evidence either from the bank itself, and when I say bank, I mean employees of the bank rather than its legal representative, or Mr. Madappa as to how to interpret this contract. What was the common intention of the parties? And I say that that is significant, and therefore, given the burden is on the applicant, it hasn't satisfied it. So, my Lord, we say, in relation to construing this settlement agreement, Article 49 and Article 51 of the contract law are complete answers to us, particularly in light of the witness statement that was put forward by Mr. Papadopoulos, the claimant's evidence. And my Lord, can I invite you to turn up tab 10 of the application bundle? And my Lord, I apologise for the length of this statement, but in hindsight, maybe it was prudent given that the claimant is no longer with us. However, my Lord, if I can just go through what the claimant says, the common intention of the parties was, and it's at page 165, paragraph 13. Given the termination of my employment was brought about by the bank's reorganisation, I wanted to ensure that I would be paid all my statutory and contractual entitlements and benefits. The bank, in exchange for making payments and commitments, wanted comfort that I would not file a claim against it for, say, redundancy once the bank had agreed to the terms of settlement and made the payments pursuant to the agreed terms. Paragraph 14, we see Mr. Papadopoulos given evidence that it was Mr. P.K. Madappa who conducted the negotiations with him. And then paragraph 17, this talks about what happened during the settlement negotiations, in that the settlement agreement went back and forth for several weeks, and various issues were negotiated and agreed upon, and clearly 17.1 deals with a compensation payment. But moving forward, page 166, paragraph 17.5 deals with how the bonus was going to be dealt with. Mr. Papadopoulos says that the bank agreed that the claimant would remain eligible for consideration for a discretionary bonus award. However, the following matters were subject to negotiation and discussion. The bank wanted the DVA to be prorated so as to exclude the garden leave. Mr. Papadopoulos argued against prorating, and the bank agreed. 17.5.2. The bank wanted the DVA to take into account the total compensation for year ending 31st of December. The claimant argued against that condition and the bank agreed. 17.5.3. Now this is, my lord, the important one. The claimant says that it was negotiated that the DVA, the bonus amount, would be $1 million US dollars thereabouts. And the claimant wanted it in the settlement agreement because it represented his bonus for 2015. However, Mr. Madappa argued that because of certain regulatory and other restrictions, it would not be possible for the bank to make a determination of the DVA prior to the normal year-end process. However, he assured me that I would be treated fairly by the bank, and in this context, he challenged me to name any past instance when the bank had treated me unfairly. In view of this assurance, I agreed to withdraw my request for the amount of the DVA to be specified in the settlement agreement. That then leads us on, my lord, to paragraph 21, where again he repeats reference to Mr. Madappa assuring him that he would be treated fairly, and that was the basis upon which he withdrew this request for the amount of DVA to be specified in the settlement agreement. And then paragraph 27, my lord, this deals with the waiver clause, and in particular clause 14. Paragraph 26, these clauses were already included in the first draft of the settlement agreement that the bank sent to me. I did not challenge these clauses because my understanding of why these clauses were included is that in exchange for the bank making certain payments and commitments under the settlement agreement, it was not strictly obliged to make it law in respect to the termination of my employment. The bank wanted certain protections from future claims in relation to the payments made, and that is what these clauses are aimed at. And this goes directly to the point of clause 15, which I'll come back and address. 27.2, I was told by the bank that these waiver and release type clauses are standard. 27.3, understanding is that protections offered by these types of clauses, included the ones proposed by the bank, were to cover the following types of scenarios: the filing of a claim in respect of payments I was contractually and statutory entitled to, so that's the compensation payment. 27.3.2, the filing of proceedings in any jurisdiction about the circumstances in which my employment had been terminated. Paragraph 28, my lord, this is the important part. It's definitely not my understanding that any release and waiver clauses apply to any future obligations and or future acts. I most certainly did not expect that clauses 14 and 16 might enable the bank to walk away from any of its commitments under the settlement agreement, including clause 13, clause 10, and clause 24, and that's the written reference clause. And just pausing there a second, my lord, in relation to the written reference clause, you'll be aware that the bank, or rather the employer, is under a duty to provide a fair reference. So, for instance, on the facts of this case, it's alleged that the claimant's management style was the reason why he wasn't awarded a bonus. Now, none of these allegations had ever been put to the claimant, either during his employment or relatively soon afterwards. The only time he became aware of it was when the decision not to award him a bonus was provided to him. Now, where does that leave us in relation to the reference clause? For instance, if the bank on written request had provided a reference to a prospective employer saying, oh, actually, he's got management issues, he's got style issues, on the basis that that had never been put to the claimant, the bank, there would have been potentially a claim against the bank for a negligent statement, for instance, or a negligent reference. And therefore, my Lord, again, it goes back to how this agreement was going to operate, or supposed to operate. It was never intended that the agreement, or rather the claimant, would waive in its entirety rights relating to any future acts. And we say that's captured in paragraph 28 there. Going back to the statement, paragraph 29 is important, my Lord, and I don't know if you want me to read those out or you'd rather read them to
well,
yourself.
I have to tell you, I'm not remotely convinced that any of this is admissible. I fully understand that a contract law requires the court to construe the contract in accordance with the common intention of the parties. But the individual intention of the individual party is of no direct relevance at all.
Well, my Lord, it requires you to go further. It requires you to look at the relevant circumstances, Articles 49 and 50, and we say that the claimant's witness statement sets out those relevant circumstances that the court ought to take into account. And it's difficult for this court to look at the common intention of the parties because the bank has not provided any evidence from...
Well, that's the whole purpose of a contractual construction, is to identify objectively the common intention of the parties.
Well, my Lord, we say that...
the words used reveal what the parties intended.
Yes, and
it may be that the words used don't reflect what the party or one of them intended, but that's tough. Anyway, I won't stop you, because
my Lord,
it's very doubtful whether any of this is admissible, and even if it is, I'm not sure I'm finding it very helpful.
Well, my Lord, I will move on. I will move on. I will only say that it might be relevant to Article 51 of the contract law, but I'll move on.
Yes,
my Lord, going back then to the settlement agreement,
yeah.
And clause 15 is where I want to start. Well, let's start with clause 13 and clause 14. My Lord, clause 13 is a very specific right which entitles the claimant to be considered for an eligibility of a bonus. That, we say, compared to clause 14, where it's a very general right, we say clause 13, being specific, ousts clause 14 because of its generality. And furthermore, clause 14, in construing this, clause 14 makes an absolute absurdity out of clause 13. Not, leaving aside the unfairness of it all, we say that there is a common sense approach, a commercially common sense approach would be to read paragraph 13, clause 13, or rather clause 14, as not waiving, the claimant not waiving the entirety of his rights, particularly in relation to being considered for the eligibility of a bonus. And the point made is that one can ask the court to strike out clause 13 on the basis that it would lead to an absurdity if the court finds that the claimant has agreed to waive his rights to pursue a dispute in relation to any future acts, be that consideration of eligibility of a bonus, be that the provision of a reference, be that in relation to the vesting of share awards. And so we say that the only proper construction can be that the claimant didn't waive his rights. My learned friend also made a point that the language is very clear. We say that in the circumstances of this particular case, where this contract allows for a future act, and in this case the consideration of an eligibility of a bonus, if clause 14 wanted to capture the fact that the claimant had waived his rights to that, then it needed to say that in very clear and very precise terms. it needed to have carved out in clause 14 that this includes not only any kind of claim, cost, expenses, but also any claim in relation to the consideration and payment of a bonus, and any other sort of future acts that this settlement agreement refers to. My learned friend refers back to the contract of employment and the basis upon which the discretion to be considered for a bonus is set out in the contract of employment. And, my Lord, I'm not going to take you there, but it's clause 6.8. We say that the contract of employment is irrelevant to understanding and construing the settlement agreement. And the reason is this. First of all, and actually I said I wasn't going to take you to 6.8, but I will, page 24.
Yeah.
6.8, 6.9, 6.10, 11 and 12, 6.11 and 12, they all provide for a mechanism by which the bonus will be considered, what the cut-off time for any bonus payment will be, and also whether or not the mechanism by which payment will be made. We don't have that, my Lord, in the settlement agreement, and therefore we say that there is a clear distinction between how discretionary variable compensation, the bonus, was to be paid whilst in employment, and a distinction between how it was going to be paid or considered after termination of employment, and therefore we say that there is no assistance to be gleaned from the contract of employment in this regard.
But the plan referred to in clause 13 must be the plan in the contract.
Well, my Lord, I don't think...
Unless there's some other plan.
No, well, no, the plan, as I understand, is the one that I've handed up in my paper. So,
Well, is the plan referred to in paragraph 6.8 of the...
there is a plan referred to, and it sets out and it gives a title of the plan. But insofar as any assistance is to be gained from in construing the settlement agreement from the contract of employment, we say there is none. It may be that it refers to the plan, and of course everyone can see that the plan is the discretionary total variable compensation plan. But that's where the assistance finishes. I mean, I don't think, rather insofar as the contract of employment refers to a plan, doesn't necessarily mean that it helps this court in construing the settlement agreement.
Okay.
In any event, my Lord, paragraph 28, the entire agreement clause,
Yeah.
we say specifically excludes the contract of employment, or rather the clauses referable to bonus in the contract of employment. By the last sentence, or second to last sentence, this agreement supersedes all previous communications agreements and or other arrangements, written or oral, with the exception of any confidentiality, intellectual property, non-compete or non-solicitation provisions within the contract, and that's the contract of employment. For the avoidance of doubt, provisions of this nature shall remain effective and applicable notwithstanding the terms of this agreement. Well, the bonus clause, we say, is not provisions of the nature set out in clause 28, which provides for exceptions.
Yeah.
And therefore one is to construe the settlement agreement in its entirety on its own. My learned friend also attempts to take assistance from Article 15 of the settlement agreement at page 48 in inviting the court to construe the waiver clause. And we say that this can be dealt with quite quickly. There is no assistance to be gleaned from clause 15 because if one reads the second sentence, constitutes full payment which may be due to you from the bank or any associated company in connection with and or arising out of your employment by the bank and or its termination up to and including the termination date. We say that that sentence on its own as a matter of construction is of no assistance to the DVA issue, because it doesn't capture any entitlements beyond the termination date. The exercise of the discretion falls outside the temporal scope of Clause 15, and therefore we say doesn't assist in construing the agreement. And so, my Lord, we say that it would be difficult, if the claimant had waived his rights pursuant to Clause 14, then it would be difficult to see how Clause 13 would work. It would make an absurdity out of the agreement, and furthermore, it would mean that the claimant loses the benefit, the entire benefit of this bargain, and we say that it was a hard-fought bargain given how the negotiations played out. Furthermore, we would say that it would make no commercial sense for the claimant to waive his right to not only being considered, but if considered and awarded, but payment of the bonus, particularly because the bonus represented almost 41% of the entirety of what the claimant says he was entitled to on termination. My learned friend referred you to the case of BCCI in this context, and it was paragraph 27 that he referred you to, and that's in the Defendant's Authorities bundle. It starts at page 34. And as I said, it was paragraph 27 that my learned friend referred you to.
Yeah.
But that needs to be read, we say, in context of paragraph 28.
Well, he asked me to read that as well.
Well, I did make a note of that. I made a note of 27.
I've read all that.
Yes, well, we say that it provides context to paragraph 27.
Yeah.
Furthermore, we say that if one turns to paragraph 32, that refers to sharp practice. And we say, and my Lord, I'll allow you to read paragraph 32.
Yeah.
We say that what is being said there, that where sharp practice is alleged, then the court ought to provide a remedy for it. And whilst we haven't pleaded sharp practice...
Well, if sharp practice is established, yes, not just alleged.
No, precisely, my Lord, and obviously, and that's why we say that this is...
This has no bearing on the bonus plan. Both parties are fully conscious of the plan. One was hoping for a bonus, and the bank at least asserts, and if you challenge it, that they gave consideration and decided, as a matter of discretion, not to award a bonus. So there's no sharp practice, is there?
Well, my Lord, we haven't pleaded sharp practice in the way that's set out here, but we have pleaded bad faith in the way that the decision-making took place.
Well, all right.
But
I
that's
was including in the word sharp practice bad faith if you wanted, but again, I think one's got to be a bit careful to just throw bad faith around like a tennis ball. What is the allegation of bad faith here, if any?
well, my Lord, I will address you on that particular question if you allow me some indulgence to get there. I just want to finish. I just want to finish this part of my learned friend submissions, and then we can deal with that. And maybe it does overlap with that, but I just wanted to point out that paragraph of BCCI. And so we say, my Lord, that, and maybe I'm repeating myself, it would be an absurdity for the claimant to agree to have waived his rights to any consideration for eligibility of a bonus. And my Lord, unless you want me to assist you further in terms of the construction, I'm going to leave my response to my learned friend's principal argument there and turn now to other arguments that he's addressed you. Turning then to the second argument that my learned friend made, and that was in relation to clause 17, and I think it's accepted on both sides of the room, that if the applicant fails on the clause 14 argument, that there is no reason to consider clause 17, and we agree with that, my lord. The only point that I would make, that given the conflict between clause 14 and, we say, clause 29, wherein it's agreed that any dispute arising out of this agreement is in the DIFC, we say that that contemplates potentially disputes, and if there is any conflict between clauses 14 then and 29, then this agreement should be construed in the claimant's favour. And my lord, in our skeleton argument, we have referred to various paragraphs in relation to general propositions in relation to how this agreement ought to be construed, and my lord would invite you to read those paragraphs. Then, my lord, turning to, or rather, sorry, I just want to make another point on this. Turning, or rather, if clause 17 was allowed to operate in the way that the bank invites the court to construe it, then we say that that would, if you like, rehabilitate the claimant's right to then bring a claim in front of the courts to pursue his statutory rights and contractual rights and termination. And so, my lord, again, it goes back to the absurdity of clause 14 if it was to act as a general debar against all and any claims. My learned friend has made an argument in relation to clause 17 that he misunderstood, or rather, the plea that we have pleaded in our reply, and I can take you to that, my lord. It's paragraph 66, behind...
I'm sorry, could you say that again?
Yeah, tab 6
of
the application.
Oh, yeah, thank you.
This is the reply, and this is where we, in this paragraph 66, we plead that clause 17 is in fact an unfair term.
Yeah.
And we rely on Article 40 and Article 41 of the Implied Terms in Contracts and Unfair Terms Law. Now, my lord, I don't think a copy of this was put in the bundle, so I have a printed copy of the relevant article. Do you have one?
Oh, sorry. Thank you very much.
So we say clause 17 is contrary and in breach of clauses articles 40 and 41 of the DIFC Unfair Terms Law. And the way in which my learned friend deals with this is to say that the settlement agreement is not a standard document, and therefore in order to be captured by Article 40-41 it needed to have been a standard document, and also that Article 40 and 41 can only relate to business documents. We say that that's a misunderstanding of Article 40 and 41, because if one looks...
So this document that you've handed to me is what?
It's Article 40 and 41 of the Unfair DIFC Unfair Terms Law. I don't have the entirety of the law.
I just wondered. Thank you.
Because what we say in our pleading, we say that clause 17, in any event, is an unfair term. And as I understand the way in which my learned friend puts his argument, he says that 40 and 41 are not applicable because the settlement agreement wasn't a standard document, and that this law of 40 and 41 only relates to business documents. And we say that that's a misunderstanding of Article 40 and 41, because, and I appreciate you don't have it before you, my lord, but if one looks at, for instance, Article 7 of this law,
Well,
it's absolute.
difficult to look at an article I don't have.
Yes, my lord, it is abstract.
I mean, he may be wrong, but as I understand the argument, if it arises at all, it is said that the unfair terms law does not apply, A, because this is a one-off contract, not a standard form.
Yeah.
And secondly, it's not issued by way of business. Now, that I had assumed, and I may be wrong, was what I call the implicit requirements of the law. If it isn't.
Well, my lord, Article 7 actually doesn't go as far as saying that.
I've got it now in front of me.
Yeah, Article 7 provides for the scope, and there is no exception provided for in that scope that extends to there being standard documents or business-related documents.
You're right. I hesitate to interrupt, but it's, as we say in Ms. Bijlani's witness statement, it's Article 38(1), which provides for standard document by way of business.
Article 38.
Yes, 38(1).
Nearly there.
Great.
Yes, I mean that seems to confine the application of the law to contracts on written standard terms of business. Now, is that a misreading? I fully understand that it doesn't deal with the question of what is reasonable, otherwise, if that's Article 40, but you don't get to reasonableness unless one is entitled to challenge the contract or the relevant provision.
Well, my lord,
What is said is that this is, on any view, not a standard form of contract, let alone a standard business contract.
yes, my lord, but it would be open to the claimant to pursue a case that this was an unenforceable term, and maybe the citation of Article 4041 is
perhaps you put it somebody could send me a copy of
the full
Article
law.
38.
Yes.
Well, Article 38 through 41. Yeah. Okay.
And so, my lord, I'm going to leave the construction of the agreement there unless there's any
Thank you.
particular provision that you want me to address you on,
Yes.
and then turn to the arguments in relation to what we say was the bad faith point, if you like.
Yeah.
And my lord, can I... Yes, of course, my learned friend will like a comfort break, my lord. I have no objection to that.
Sorry?
I'd be grateful for a comfort break.
Oh,
I'm very grateful.
Yeah, okay. Well, shall we take an early lunch then? Is that better? Right, we'll resume at 1:30. Is that, are you happy with that, Miss Simon? Well, if we take a comfort break, you're going to finish before 1 anyway, are you?
I'm hoping to finish before 1, but if I am later by 5 or 10 minutes...
Oh, yes, I'm not going to complain about that.
Okay, well, in which case...
Right,
then
let's take 5 minutes then.
I'm
yes.
grateful to you, my friend.
For us.
This is his part, you know, I thought part 3 was fair terms. No. Yeah, I've had a read. Yeah, I've had a read of it. Yeah. to the article. Isn't it unfair to... This isn't a contract, but it does not apply to it, yeah. 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 Exactly, yeah, I think you're right. Because I think that's how I read it the first time around, which is why I must do it again. He hasn't got it. He's got that. Just give him that. I might come to it again, because he's really over that. Yeah, exactly. Yeah. No. Yeah. I bet I'm going to say it. I'm going to say
Is council ready?
Yeah.
All rise, please.
My Lord, I was then going to address the arguments in relation to the claimant's pleaded case, and my learned friend made the submission that the pleaded case doesn't come up to scratch. And we say that that demonstrates, again, the little understanding that the other side had of the claimant's case. And if I can refer you to the particulars of claim, it's in the application bundle behind tab 2. The claimant's case, in a nutshell, before we turn to the pleading, is that A, clause 13 entitles me to be considered as eligible for a bonus. B, that consideration has to be in compliance with Article 57 of the contract law, in that it should be in good faith, fair dealing and reasonableness, and or that it's perverse, that it's not perverse and irrational. And in a nutshell, we say that is the claimant's case. Page 1 refers to the parties. Page 1 of the pleading is page 2 of the bundle. Page 3 goes through the background facts. Page 4, settlement agreement. Page 5, the bonus rating. 6, again, facts. Page 7, the grievance process. And my learned friend again criticises the claimant for referring to the grievance process, but we say it's important because it demonstrates the way in which the bank dealt with the claimant and how evidentially that's important when the court may come to decide the question of bad faith. But turning again, sort of going through the pleading, grievance appeal, the claim, page 11.
Yeah.
So, my lord, the title there is breach of express term of the settlement agreement. It's not simply the breach of the express term of the settlement agreement, but also the implied term pursuant to the contract law, and that's Article 57. And I know it doesn't say that here, but we can find that if one looks at paragraph 42.
Yeah.
The claimant was eligible to be considered for a discretionary bonus. The claimant was perversely and irrationally assigned unjustified values of D. And then paragraph 43, Mr. Winter's decision to award claimant a D rating was unreasonable, capricious and in bad faith. And if one turns to, my lord, Article 57 of the contract law, it's behind tab 1 of the claimant's authorities bundle. You have it? My lord, is that what you said?
Yeah, I got it.
Yes. And one can see that there is an implied obligation of good faith, fair dealing and reasonableness, and we say that that's captured in paragraph 43 of the particulars of claim. And so it's the exercise of the discretion.
Well, I don't want to spend time on a pleading point, but this is all under the heading breach of express term.
I understand that, my lord.
As I understand it, it is not, or I assume not, it's not contended that the bank never considered the claimant in terms of eligibility of the bonus at all.
No, and it can't be,
Yeah.
on the basis of
So
the evidence.
the only point that could be raised, and although it's pleaded in a very strange way, is that the claimant, I'm so sorry, the bank acted perversely or irrationally in refusing to grant him a bonus.
And in breach of Article 57. And I see on review of these pleadings that it doesn't set it out in plain language. And
What more troubling is that when it does get to
Yes.
apply terms of good faith, it relies upon 2 points that have absolutely nothing to do
Well-
with the consideration of the bonus.
yeah, well, my lord, and again, I take the point that this may be a defective pleading point. However, we
Yeah,
say
you're all
that,
right. Now, I don't want to waste time on it, but it just slightly undermines the general credibility of the, if I may use that word, of the concern as to the way in which the bank had behaved.
well, my lord, I take on board that point, but in answer, what I would
Anyway,
say.
let's stick to the point, which is
Well, my lord, to explain the pleading, we say, and clearly there is language there that one can tease out to say that there is a claim, number 1, for breach of Article 57, and that the bank exercised its discretion perversely and irrationally. And whilst the title there at page 11 could say breach of express and implied term brackets pursuant to Article 57. This in itself, we say, doesn't mean that this case is suitable for immediate judgment, just because a pleading omits to mention a word. And we say it's not suitable for immediate judgment. And if one reads the pleading, and again I go back to 42 and 43, one can tease out the breach of Article 57 point that is made. And so, once Article 42, Clause 42 and 43 of the pleading, we say, sets out the breach relied on, which is of the implied obligation under contract law, clauses or paragraphs 43.1 onwards then set out the reasons why the claimant says there has been a breach of Article 57 and the decision making was perverse and irrational. And that's all contained in paragraphs 43.1 onwards. 44.1, where there is reference to the grievance policy. Now, we don't say that this amounts to a freestanding claim. However, what the pleading has attempted to do here is provide evidential information as to why it is said that the bank is in breach of Article 57 and bad faith, if you like, by giving evidence as to the way in which the grievance process was treated. So, put differently, my Lord, we say that the grievance procedure didn't follow the bank's own policy in circumstances where the bank said it would. There were various breaches of that policy, and the reason why those breaches of the policy came about is because the defendant was acting in bad faith when it came to considering the claimant's eligibility for a bonus.
Well, I simply don't understand that. How do you say that because the defendants acted in breach of the grievance procedure, it demonstrates that they were acting in bad faith and refusing to grant a bonus? I simply don't understand it. Well, it may be you say that the DIFC law should be different from the approach of the common law courts in England. Mm-hmm. But on one view, and certainly the view being advanced by the defendant, it is up to you, on behalf of the claimant, to demonstrate from the award, or in a sense lack of award, or the circumstances in which no award was made, that there is implicit irrationality or perversity. Now, what is it that you point at to demonstrate perversity?
Well, my Lord, in which case, let me take you to the documents that I've put before you, the extra documents,
okay.
And hopefully they'll be in chronological order. The first
one. Looking at your little bundle you handed up.
Yes.
Hang on a minute. No, I can't find it. Where did I put it? Oh, do you have? Here it is. I'm sorry. I've got it there. Yeah, I have it.
My Lord, before I take you to those documents, can I just refer you to one authority, please,
sure.
Because that will assist in when we look at the decision-making process. It's the defendant's bundle. It's the case of Braganza, which my learned friend referred to in his submissions.
Yeah.
And the issue in this case was that there was an exercise of discretion by an employer as to payment of death in service benefit. And my Lord, can I invite you to turn to page 182?
Yeah.
And it's paragraph 19. There is an obvious parallel between cases where a contract assigns a decision-making function to one of the parties and cases where a statute, or the royal prerogative, assigns a decision-making function to a public authority. In neither case is the court the primary decision-maker, primary decision maker is the
At
contracting...
your page, where are you reading?
Sorry, paragraph 19, page 182.
Sorry. Yes, I'm sorry.
Yeah, my Lord, I'll allow you to read that paragraph.
Yeah, I'll read it. Hang on.
Yes.
Yeah.
Yep. Paragraph 22, my Lord. This is where Baroness Hale cites from a judgment of Lord Justice Riggs in the case of Sockimo. If you perhaps could read that dicta from paragraph C to F. It is plain from these authorities.
Yes, just reading that. Thank you. Yes.
And then paragraph 23, please.
20.
3, following paragraph.
Thank you.
So, my Lord, what we glean from this, or what I glean from this, you may completely differ in your view, but we say rationality, or when looking at rationality of a decision, the minimum objective is the standard of the minimum objective standard of the relevant person's mental processes. And so therefore, my Lord, there has to be some logic between the evidence and the reasons for the decision, and whether or not relevant circumstances were taken into account. And we say, on the face of the documents that I'm going to take you to now, there is a gap, a huge gap between the logic of Mr. Winter's decision-making process compared to the decision itself. And, my Lord, if I can perhaps now invite you to turn up those documents that I handed up at the start of the hearing.
Yeah.
So the first document is the discretionary total variable compensation plan.
Yeah.
And if one looks through the document, page 3 sets out the definitions, and clause 2, purpose of the plan. Purpose of the plan is to support a strong performance-oriented culture, ensuring the individual reward and incentives related directly to the performance and behaviour of the relevant participant, long-term and sustainable performance of the business and the interests of the shareholders. In this instance, the relevant point is the performance and behaviour of the relevant participant. If one then turns to 5.1, paragraph 5.1, it talks about the performance should take into account performance against individual objectives, performance relative to peers, and demonstration of the group's value and adherence to group's risk profile. My Lord, there is nothing before you that would allow you to assess how group values and adherence to group risk profile is to be assessed. And that clearly could only come before the court as part of disclosure. But at this point in time, my Lord, there is nothing before you, and nor was the claimant provided with any sort of table, guide or assessment as to the group's values and how he had underperformed against them. If I could then, and I apologise for going backwards and forwards, can I then ask you to go back to the application bundle? And you've already been taken to this document by my learned friend. It's the historical P3 data summary, and it starts at page 156. Now, this document, my Lord, works backwards, and so if I can ask you to turn to page 159. So the first box at the bottom is the 2010 final bonus award, and we see that the claimant has been given a rating of 2B, and that was by his line manager at the time.
159, where are you reading?
At the bottom. So if you turn it sort of landscape, There's a box right at the bottom.
2010 final.
Final, yes. The claimant's been given a 2B by the country CEO, Vizchenko, who was his line manager at the time, and there is nothing there in relation to the claimant and his management style. 2011 final, the box above that, again, he's been given a 2C, Vizchenko, and what we see the note is reading at the bottom, great effort, thanks. And whilst the second paragraph refers to the claimant benefiting from managing his CEOs more directly on both positive and negative matters rather than relying on communications, there is nothing within that blurb in relation to his management style.
But I have a fear that you would suggest that the rating of 2C is an indication of bad faith because it was 2B the year before.
My Lord, the indication of bad faith... Yes, but let me deal with... I'm dealing with the irrationality perversity point first because I thought that's what you asked me.
So what do I get from 2011 final?
Yes, my Lord, let me just... In terms of how I intend to deal with this, I want to deal with the irrationality perversity point first and then deal with the bad faith. So 2012...
Well, I have to say, if you're trying to require me to distinguish between irrationality and bad faith, I'm not sure I can. What is... If one acts in bad faith, by definition, I suspect you're acting irrationally. If you act irrationally, you're by definition acting in bad faith.
Well,
unless you have no idea what you're doing.
Bad faith, we would say, extends further than irrationality. Irrationality, we say,
the
is...
issue here is it arguable that the bank adopted an irrational or perverse stance?
Yes.
And bad faith adds nothing. Although I understand your proposition, sorry, I don't understand, but I understand that you make it, that there was some additional want of good faith in the way in which the settlement agreement was negotiated at one end of the story, and the grievance procedure was pursued at the other end of the story. But I put those 2 points aside. For the moment, let's focus on the eligibility for a bonus and the decision not to award.
Yes. Okay. Well, dealing with that, my Lord, and please bear with me. Apologies for taking you through this sort of dense document.
So, but for 2011, which was the bit you wanted me to...
Well, let me make this point sort of more concisely rather than go to the sort of small print. What I'm saying in a nutshell, my Lord, is this. Up until 2014, the claimant's conduct in relation to his performance was satisfactory, and there were no management stylistic issues raised with the claimant. That's a simple point. And if one reads the small print in these boxes, we say that in fact his line manager appreciates his efforts. He says thank you, and I can see, my Lord, you're reading this now. Can I direct you, my Lord, to page 158?
158, yes.
Yes.
And
and you've got 2013 final.
Yeah.
Vizchenko again. And can you see the second paragraph where it's underlined, Christos provided credible leadership to the region? Nothing within this blurb complains or criticises his management style. That's the simple point. If one goes up on page 157 and 156, and this is the important part of this document. At 156, we can see the second entry being 2014 final, and it's 2B, and it's awarded, my Lord, by Bill Winters. 2 points to be made here. My learned friend made the submission that the reason why Bill Winters initially had given a rating of 3B, because you'll remember Bill Winters at the mid-year mark, June 2015, gave a rating of 3B, which was then changed at the end of the year to D. So that's part of the sort of irrationality argument. Where he gives a rating of 3B, the bank's position is that he'd only been in post for 4 weeks. And in any event, stylistic issues relating to issues around sort of London and Singapore-based seniors had been raised, and that was the reason for the decision. We say that that can't be right on the face of this document. Mr. Bill Winters gave the final rating to B in 2014, and therefore he was in a position to assess the claimant's suitability or performance, or whether or not he'd adhere to the bank's values, because he provided the final rating in 2014. And in fact, what he said in 2014 was, Christos has shown strong leadership in addressing the strategic initiatives in his region. Over the page at 157, he's actively encouraged and provided airtime in all his governance. And my Lord, I'm simply reading those underlined sentences.
Yeah.
Feedback number 2, Christos has excellent leadership skills. He has a unique ability to swoop and soar, thereby providing effective leadership. Very matured and balanced in his approach, has a keen sense of duty, and is extremely fair in his approach to staff and situations. He, under feedback 2, last bullet point, he lives the values of the bank by being courageous and not being shy of taking bold decisions where risk issues are being addressed. He provides excellent guidance on the strategic intent of the bank, very balanced in his approach. It's a real pleasure to work with him. And so it was Bill Winters, in fact, who writes that and gives his final rating of 2B.
Yeah.
At the end of March 2014. And so the defendant's assertion that Bill Winters wasn't imposed and therefore the rating changed from B at mid-year to end of year D just doesn't hold water, my Lord. And this is the defendant's document that the defendant has produced, attached and exhibited to Mr. Vigilani's witness statement. So we say that's one reason why we say that the decision-making, or it's alleged perversity of the decision-making. The second, and just to add to that point, my Lord, what the claimant says about Bill Winters and him being imposed is in his reply, or how long he was imposed, is set out in his reply at behind tab 6.
Sorry, just hang on. So sorry, yes, please.
Yes, it's the reply, tab 6,
Yeah.
page 103,
Yeah.
and it's paragraph 8. And the claimant denies that Bill Winters was imposed for a matter of weeks, and he sets out his reasoning as to why Bill Winters was in a position to give a fair assessment of the claimant's performance ratings. And I'll allow you to read that yourself, my Lord. It's the whole of paragraph 8.
Yes, just hang on a minute. I'm having a look at the dates here. You kindly showed me the historical data summary,
Yes.
including Mr. Winters' allocation of 2B final 2014. But this pleading
So the rating.
refers to an appointment in February 2014.
Yes, but the rating was given in March of the following year. March 2015.
Oh, I see. So, well, I think I understand.
So the bonus is awarded for the end of year 2014, but the actual decision is made, as I understand, at the end of March of the following. Yes.
The 4 months prior to the 25th of July 2015 is as from March 2015, correct? Mr. Winters has extensive dealings with the claimant, so the only extensive dealings he had with the claimant were in the 4 months from March to July 2015. That's how I read the sentence. So I'm not understanding how he's able to make any observation about his performance in 2014.
In the 4 months prior to awarding the claimant the pre-rating.
Anyway, this is what, as I understand, your client says.
Yes, and my lord, whilst I don't have it with me, I do have, or we do have in our possession further documents provided to us by the claimant before his passing, and a proof of evidence, and it may be that I would need to go through the documents again, just to confirm what is meant by that.
Mr. Winters has changed his view.
Yes, so that's one piece of the factual matrix that we say lends itself to this bad faith argument. The second one is the way, or the theme rather, is the way in which the reasons for the rating developed over time. And Mr. Papadopoulos' argument is that they've changed from when he was first informed as to why he was getting a D rating to when the grievance outcome was provided to him. And so, my lord, if I can just take you through those change of reasons. He was first informed by Mr. P.K. Madappa as to his D rating, and I think it was a phone call on the 9th of March, and we take that from the particulars of claim behind tab 2. Paragraphs 21, 22 and 23. So he receives a phone call on his page 6. He receives a phone call on the 9th of March, or rather there's a conference call with Mr. Madappa where he's been told he's going to be valued a D rating for the year 2015, and therefore he's not going to be awarded a bonus. And we see that a D value rating is awarded when an employee only sometimes lives the values and demonstrates expected behaviours of the bank. Paragraph 22 is what the claimant says Mr. Madappa gave as reasons for being awarded a D. So you have that there. The conduct issues in UAE since March 2012. Tough management style, based on input from group investigations, and number 3, personal financial transactions with Mr. Afaq Khan. Now, so those were the reasons the claimant says were provided to him on the call on the 9th of March. Then we turn to, and we're going back to this, the sheet of papers that I handed up this morning. Hopefully it should be at page 16, the document that I want to take you to. It should be an email.
What page?
16.
Yes.
It's an email titled 2015 Rating Bonus,
Yes.
13th of March 2016. So after the phone call, the claimant writes to Bill Winters. Interestingly, he copies in Mr. Madappa.
Yeah.
And the first thing he says is, well, it's not in my contemplation, but I wouldn't be be receiving a bonus. So let me start by saying that the issue of my 2015 bonus rating was not something that I expected to have to raise with you. And then we go down, first, second, third paragraph. I have been informed by PK that my rating for 2015 was 3D, and as such I will not be awarded any bonus. I wish to challenge my D rating in the strongest possible terms. There were 3 reasons given to be my PK. Number 1, various conduct issues in UAE, including quality of CDDs. 2, very tough management style, which in some cultures will be seen as bullying or intimidating based on the work carried out by group investigations. And number 3, the way I dealt with the investigation related to Afaq Khan, including a suggestion that I might have been personally implicated in some transactions with Afaq Khan. So as of the 13th of March, the claimant is reiterating the reasons provided to him by PK Madappa as to the rating. And my lord, PK Madappa doesn't, or rather we don't have any documents or emails or anything of that nature wherein PK Madappa has come back and said, actually, Mr. Papadopoulos, Christos, I didn't give you those reasons, my reasons were different. And so it has to be accepted on the balance of probabilities that those were the reasons provided to the claimant as to his D rating. We then see Mr. Winter's response to that, and that's at page 19.
Yeah.
Suspension of vesting of shares, 17th of March. And again, we see PK Madappa copied into this email. And the first bit is the first, second, third, fourth, fifth paragraph, 5 paragraphs are in relation to the awarding of shares. And at the bottom of the page where we see bonus and D rating, I'd like to respond to your email concerning your bonus and 3D rating. A D rating means that the employee of the page sometimes lives...
I mean, this is the same document we saw earlier, yes?
Yes.
Yeah, okay.
Well, I think you saw the grievance outcome earlier. I'm not sure this you were taken... I don't think you were taken to this document.
The 17th of March,
Yes.
Yes.
Oh, my apologies, you were, my lord. Yes. Yes.
Okay, thank you.
So the first...
So this is the notification, in effect?
In effect, yes, from Bill Winters. But what Mr. Winters says about the reasons for the D rating, we say are different to the reasons provided by Mr. Madappa. Because if you look at the first paragraph, second sentence on that page 20, the rating reflects and takes into consideration the feedback received regarding your overall conduct and behaviour and treatment of colleagues. So that's the general theme here. Paragraph 2, it then says, the value rating reflects your values and behaviour and the feedback received from a number of employees. Multiple complaints were raised with regards to your management style, which was described as intimidating, aggressive and bullying. Employees were intimidated by you. Complaints were mainly from employees more junior than you. These complaints were not raised by members of the investigation team. And my lord, what's important to note here, that there is not a shred of evidence provided to date by the bank, either when they were substantiating their D rating to the claimant around the 17th of March, or when the claimant challenged the decision as part of the grievance process, as to these complaints that are being referred to and rely on to deprive the claimant of his bonus. And we said that's really where the grievance process and the bad faith allegation ties in, because there simply is no evidence provided to date. And as part of the...
So, I mean, what the inference you say I should draw is that these complaints about his style were invented.
Well, there is no evidence, and
Well, perhaps you just answered the question.
well, on the face of the evidence...
What is needed here as to is to see whether there's the decision not to award him a bonus was arguably perverse or irrational.
Yes.
And what is the consistent theme in the documents at least we've seen so far, but maybe more, is that the bank had a dim view of Mr. Papadopoulos' style.
Well,
And now you may say that if you were the bank, you might take a different view, or another bank might take a different view.
but my lord, that dim view only surfaced around March of 2016 when a bonus had to be awarded.
So that's what you say,
He was-
it was invented.
Well, yes, Yes. There is no evidence that the bank has provided to date of this dim view. The claimant was never...
But they have produced evidence. You've got Mr. Winter's statement.
Well, my lord, you can't simply have a statement, oh, look, I think you bullied employees. What's that statement based on?
Well, this court is not here to consider the evidence that the bank received. The question we're considering here is whether the bank acted perversely.
Well, my lord...
Now, you say that they haven't produced any explanation or evidence in relation to the basis of their decision, but you simply can't go that far.
Well, my lord, I say that Braganza and the paragraphs that I referred you to actually direct the court to take the approach of linking the mental process, the decision-making process, with the decision itself. And if there simply is no evidence, then how can one actually even say the reason why Mr. Bill Winters took this decision is because he had X, A, B, C pieces of evidence? We say that Braganza invites the court to look at the decision-making process as well. And we say that in this case, the decision-making process in the absence of evidence is woeful to then attempt to justify a derating. Bearing in mind, my lord, as well, that if these complaints had been made by junior employees, then at no point was the claimant ever told about these complaints, nor was he ever given an opportunity to respond. And we say, therefore, that this was a unilateral decision on the part of the bank at a time when a bonus had to be awarded, to say that then at that point to take a dim view using your words. And my lord, going back to the essence of the application then, just taking one step back. This case, we would say, therefore, is not suitable for summary judgment because there is serious live issues of fact between the parties, and these would only be tested properly by disclosure, by witness statements and tested of the evidence. And we say, therefore, that even now, at this basis, going through these documents, it's clear and plain that this case isn't appropriate for summary judgment or immediate judgment. And my lord, just sticking with this point, the lack of evidence, if you like, the respondent wanted to rely on a document as part of this pack, and that's at page 8 of this bundle, of this sheet of papers that you have. And it's an email from Stuart Works, who's an employee of the bank. It's dated the 26th of May 2015. And it's to a gentleman called Michael Welch. Just a quick report. We interviewed the first Newport speaker. I think that's part of some sort of a grievance process. It was anticlimactic. The witness detailed the issues surrounding the blank, Christos blank, pushed to support the problematic female employee. But beside the bullying and veiled threats that permeate the environment here, the witness could not point to concrete instances of wrongdoing or any indicia thereof by this trio. Trio, we don't know who that's referring to. We got a few tidbits, interviewed the more promising witness tomorrow, and have identified a third we hope to speak to as well. But for now, unfortunately, not much new, more formal reporting follows from Matthew. Now, the inference that you can only draw, my lord, from this email, given the date, the 26th of May 2015, that it clearly didn't lead anywhere. The claimant was still imposed on the 26th of May 2015. His employment ended 31st of December 2015. And there were no complaints, no processes adopted by the bank against the claimant in relation to allegations of bullying and harassment and so forth. And so we say that it is important in this case to actually consider Bill Winter's mental process and what it was that he was looking at when he came to make the decision that a bonus ought not to be awarded because of a D rating. And then, my lord, again we see a change. So, sorry, just again staying with this Bill Winters email on the 17th of March. Mr. Bill Winters says that it's complaints raised by members of the team. Nothing was ever put to the claimant. The third paragraph in that email, page 20, you mentioned the Bahrain issue. You escalated this issue. This was most unhelpful. But Mr. Winters doesn't say that that's the reason why a D rating was given.
So it's not.
It's not.
He said it's not the reason.
Yeah? It's not the reason. So it's a change from what PK Madaka said to what Mr. Bill Winters is saying on the 17th. Second to last paragraph on the bottom, page,
So where are you now?
page 20. I'm identifying, my lord, the discrepancies between what PK Madaka said on the call and what Bill Winters is saying in his email. Second to last paragraph, I can confirm that the bank has no clear evidence so far of any personal financial dealings with AFAC, and this was not a consideration. Satisfied there is enough evidence of your failure to treat colleagues fairly. And so, my lord, this shows that there is a discrepancy between what Madaka was saying and what, in fact, Bill Winters did take into account. And what he did take into account, we say, there is no credible evidence for that, nor any substantiation. And if one looks at it in the timeline of events, bearing in mind the email that I've just taken you to, the May 2015, the claimant wasn't even aware that there were these issues within the organisation, had no opportunity to respond to them at a time when he could have done. And then, my lord, if I can ask you to turn to, it should be in your bundle, I think it's page 24. It's an email from Neil Cuthbertson, 1st of April 2016. And what the claimant says in his pleadings, and my lord, I can take you to that, is that there is an inference here that the bank is almost trying to find reasons for giving the D value rating, and that's why we see there points for discussion. Did he do an adequate handover, fully documented? Is he subject to Project Widgeon? Just ideas as to why he could be given a D rating, and that's dated the 1st of April 2016. And it may be just quicker to circumvent this instead of going through the documents if I just take you to the pleading, my lord.
Yeah.
It's behind tab 2. Where, and it's page 14, paragraph 45.1. These refer to documents that Mr. Papadopoulos obtained pursuant to a data subject access request.
Yeah, sorry. Divider?
2. 45.
Oh, yeah, sorry. The numbering. 45.
So this is reference to documents.
Now the grievance process.
Or 45. These were documents that the claimant obtained as part of a data subject access request. And 45.1a is the email of the 5th of April 2016. Now, Ms. Walkden was tasked with looking at the reason why the claimant was given his rating D in an objective and impartial manner. And what we see here, that in fact, it makes reference to a conversation between the grievance investigator and Mr. Winters, in that Bill has agreed that we do not negotiate on money, but we do a limited review of the values rating. This should not be a full review of Bill's judgments on the values. This is the person that the claimant criticises and complains against, telling the grievance investigator how to run the investigation and run the grievance. And so that, the claimant says, is part of the bad faith factual matrix, particularly because it's in breach of the grievance, of the bank's own grievance policy. My lord, that grievance policy, just for your information, is in the bundle. And if I could invite you to very quickly take a look at it.
I should never pay any attention to your estimates of time this time, I think considering my finish my one. How long are you going to be?
My lord, I may be another 10 minutes.
I think that's what you said last time. All right, well, you can have 10 minutes and that's it.
I'm great.
Alternatively, we'll adjourn.
Okay. My Lord, I may just take a break and at least we can take this.
What's your mind?
I'm not rushed, yes.
Take that as escape clause. Right. We'll start at we'll start at 2:15. Okay.
Yeah, grateful, thank you.
All rise.
Obviously, I'm reviewing it. But intense scrutiny. Of course I accept that. But you've got to look at where this logic comes from, at the very least. Yeah. One can clearly see that.
I'll just show you very
Construction is construction.
No, it's purely future performance. That's actually
Yeah. Yeah. But you know, the answer is perfect in my opinion. Kind of the test. Yeah. Oh yeah, no. Yeah, no, that. I'm sorry, I'm going back to what I was talking about. Yeah. So, you know, you've got to. You've got to understand what's in the brain. Yeah.
So yeah, have a nice lunch.